When John's mom, Sarah, was ready to create an estate plan, John selected the best lawyer in town to help her out. Since Sarah didn't have much, her primary concern was to make sure that John was able to inherit her home. Sarah's lawyer was phenomenal, and the lawyer created an effective last will and testament. Sarah and John were happy, believing that they had taken all of the steps necessary to complete Sarah's estate plan. Years later, after Sarah had passed away, John and his family moved into Sarah's home, where they lived happily until one day when a major storm hit. Unfortunately, the first floor of the home flooded during the storm, causing nearly $50,000 worth of damage. John was glad that he had continued to pay that homeowner's insurance policy that his mom had taken out many years before. However, when John filed an insurance claim, he was shocked to discover that his claim would not be paid. The adjuster stated that since John was not the owner of the home, his claim was not covered by the homeowner's insurance policy. John was outraged. He responded to the adjuster that he does own the home, and he forwarded Sarah's last will and testament to prove it. However, the insurance company again refused to pay the claim. The adjuster pointed out that being listed in the last will does not prove that John is the owner of the home. What John did not realize was that he should have submitted his mom's will to probate after her death. Since he had not done so, legal ownership of the house had never transferred to him. That being the case, if John wanted the repairs done, he would have to pay for them out of his own pocket. What went wrong? No matter how good a last will and testament is, if a person owns an asset in his or her own individual name, the ownership of that asset cannot be transferred to their loved ones until their estate has been probated. The probate process is different in each state. In addition, some states have both an expedited probate process and one that's more complex. In Illinois, if a person owned a home, regardless of the home's value, the person's estate goes through the most complex probate process. Here are some of the steps involved. The probate process begins when someone files a petition to open probate. Once opened, if there's a last will and testament, that must be filed and approved by the court. Then potential creditors and potential heirs must be sent notices, and notice of the estate must be posted in the newspaper. The steps you see are just a few of what the deceased loved ones may have to endure. Does this probate process sound inexpensive? Does it sound easy, quick, or painless? Or does it sound like something most people would want their loved ones to avoid? The probate process applies to estates where the person died owning an asset or assets in their individual name. This includes people who have a last will and testament or no planning documents at all. In addition, if a person has a living trust but fails to put one or more individually owned assets into their living trust, that unfunded asset may need to be probated as well. If a living trust is fully funded, the probate process may be avoided completely. Speak with your attorney about whether having a fully funded living trust suits your needs. Then direct your attorney to visit LegacyComplete.com, where you can work with the attorney to create a customized living trust for prices starting at $500. Before I wrap this up, I want to highlight what I feel is the biggest reason to avoid the probate process: the fact that the files are public. Virtually anyone can view the files and see what was left to whom. Right now, you're seeing pages from Michael Jackson's probate petition and Whitney Houston's will. Chances are you've lived your life privately and you don't want your business posted over the internet after you're gone. Please talk to your attorney about your options and consider creating and fully funding a living trust customized to your needs.